My name is Summer Richmond, and this is my presentation on employee discipline. Historical overview of employer disciplinary policies. During the 18th and 19th centuries, the employee exercised unrestricted discretion in directing the work crew. In 1884, a judge in the state of Tennessee wrote the following: "All may dismiss their employees at will, be they many or few, for a good cause, for no cause, or even for cause morally wrong, without being thereby guilty of legal wrong." This judge's statement laid the foundation for the common law employment at will doctrine. Employment at will doctrine. Under the public policy exception to the employment at will doctrine, employee is wrongfully discharged and if and when the discharge is inconsistent with an explicit, well-established public policy of the state. For example, an employer cannot discharge an employee for filing a workers' compensation claim after being injured on the job or refusing to break a law at the direction of the employee. Present-day significance of discipline. Disciplinary systems are designed to discourage problematic behavior and to quickly correct problems when they are discovered. The first-line supervisor is usually the first person to become involved in disciplinary action. The first-line supervisor usually conducts the initial investigation of the facts surrounding the employee's misconduct. It is usually the first-line supervisor who recommends disciplinary action or has the authority to take disciplinary action. Due to certain employee rights, they must be protected, so some employers may decide to have an oversight of the supervisor's decision to discipline and require higher-level approval before disciplinary action is taken. Therefore, it is possible to introduce some level of restriction on supervisors to protect employee rights without adversely affecting supervisors' belief in the effectiveness of the disciplinary system. Discipline for just cause. Government agencies such as the EEOC and the NLRB indicate that discipline must be for just cause, which must meet the following criteria. There is clear and convincing evidence that a disciplinary offense was committed by the grievant. The disciplinary action taken by management was appropriate for the offense committed. The disciplinary cannot be arbitrary or discriminatory. Instead, it must be applied consistently to employees given similar circumstances. Disciplinary efficiency purposes. Disciplinary efficiency can improve itself by accomplishing the following interrelated purposes: to set an example of appropriate behavior, to transmit rules of the organization, to promote efficient production, to maintain respect for the supervisor, to correct an employee's behavior. Proof of disciplinary cases. Arbitrators use 3 levels of proof: preponderance of evidence, wherein testimony and evidence must be adequate to overcome opposing presumptions and evidence; clear and convincing evidence, which shows the truth of the facts asserted is highly probable, beyond a reasonable doubt. This represents a higher degree of proof, which some arbitrators in the criminal cases such as selling illegal drugs on company property or stealing that can more adversely affect the grievant's chances of finding a subsequent employment. Progressive discipline. Progressive discipline refers to increasingly severe penalties corresponding to repeated identical offenses committed by an employee. It's related to a correction in at least 2 ways: by impressing on the employee the seriousness of repeated rule infractions, by providing the employee with opportunities to correct his or her behavior before applying the ultimate penalty of discharge. Steps to progressive discipline. An oral warning represents an informal effort to correct and improve the employee's work performance. A written warning, the next step in progressive discipline, is a more serious matter because it summarizes the previous oral warnings to correct the employee's behaviors and is entered in the employee's work record file. A suspension is a disciplinary layoff without pay given by management to impress on the employee the seriousness of the offense. And then you have discharge, which, unlike suspensions or warnings, is not a corrective measure because it means the employee is permanently removed from the company. Last chance agreements. A last chance agreement is a negotiated written agreement signed by an employer, union, and employee whose conduct has been determined to be unacceptable. Mitigating circumstances. Arbitrators often consider mitigating circumstances which might reduce management's assigned penalty based on one of 3 assumptions. Management contributed to a problem and must therefore assume part of the responsibility for the wrongdoing. the circumstances of the case were so unusual as to give great doubt that it will occur again, particularly if management uses corrective techniques instead of discharge. And personal factors causes a stressed or troubled employee to perform the disciplinary incident. Therefore, the employee will not continue these infractions once his or her personal problems are identified and resolved. Application of the just cause standard. In general, the arbitrator has the responsibility in discipline cases to determine whether an employer has applied the just cause standard. Just cause is generally considered a universal standard by which to evaluate employers' disciplinary action. Due process. Due process has both substantive and procedural aspects. Substantive due process focuses on the purpose or rationale of the work rules to ensure that an employee has not been arbitrarily disciplined or discharged. Procedural aspects of due process. Procedural aspects of due process are usually covered in labor agreements and include the following: the existence of a procedure that has rules, is known, is predictable, and is not arbitrary, is applicable and administered equally to all employees, includes the right to be represented, the right to present evidence and rebut charges, the right to know the charges, and the right to relevant information concerning the charges, the right to fair and impartial fact-finding process and hearings, and to be free from retaliation, the right to as much privacy and confidentiality as practicable. Conclusion. In many respects, employee discipline represents the most significant day-to-day issue in administering the labor agreement.